Welcome to Epstein Becker Green's Employment Law This Week podcast. I'm George Whipple. The current administration is attempting to expand the president's authority to terminate members of independent agencies like the NLRB and EEOC without having to demonstrate good cause. Several current and former members are pushing back, arguing that Supreme Court precedent limits the president's authority in these cases. Chief Justice John Roberts has allowed the temporary removal of NLRB member Gwen Wilcox and Merit Systems Protection Board member Kathy Harris, while the administration's appeals proceed. The appeals are to be heard and likely decided by the United States Supreme Court on an expedited basis. To dive deeper into the constitutional questions, we turn to my colleague at Epstein Becker Green and former acting Attorney General of the United States, Stuart Gerson.
The Supreme Court is almost certainly going to take up this case, and the issue is the application, the current viability of a case called Humphrey's Executor against the United States. That is a case in which a unanimous Supreme Court considered the power of the President of the United States to remove executive officials of quasi-legislative or quasi-judicial administrative agencies, in that case, the Federal Trade Commission.
The 1935 Supreme Court ruling in Humphrey's Executor found that the president may not remove an appointee to an independent regulatory agency without good cause. One issue that both sides are arguing now is whether the agencies in question are, in fact, independent.
They have mandates from Congress. They're likely more creatures of Congress than they are the executive. The executive didn't establish them. They're departments, if you will, or sub-departments that are defined by the Congress. On the other hand, what branch are they in?
These are some of the issues the court may consider if it takes this case, after the Court of Appeals for the D.C. Circuit rules on the pending appeal. Stuart tells us more about potential outcomes if they do.
The easiest one to describe is the most radical one, which is to abolish Humphrey's Executor, simply to overrule it and say that these are agencies which, if they're in any branch of government, are part of the executive branch, even though they don't fit in very easily, and that we believe in the unitary executive to the extent that a president may hire or fire, subject to the appointments clause of the Constitution, anybody who he wants to support his policies. On the other end is simply to reaffirm Humphrey's Executor and say that the president did not have the authority to fire a member, say, of the National Labor Relations Board for anything other than cause. And then there's the third option, which is something in the middle, which is to define for cause and allow termination only under the most stringent of circumstances that are delineated by the court.
If Humphrey's Executor is overturned or substantially narrowed, this could have major implications for federal agencies and for employers.
The implication for agencies and for the people who rely on agency determinations in those industries, including employers, is profound, because it will turn what have essentially been non-political functions into entirely political functions. Well, that profoundly will affect the conduct and particularly the planning of employers, how they deal with their workers, how they deal with the total environment that they operate in, whether it's trade or dealing with their own personnel.
Thanks, Stuart. Thanks for listening. We'll see you next time.
This podcast is presented by Epstein Becker Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.